Brian Armstrong. There is some noise about a disclosure we made in our 10Q today about how we hold crypto assets. Your funds are safe at Coinbase just as they've always been. This disclosure makes sense in that these legal protections have not been tested in court for crypto assets specifically, and it is possible, however unlikely, that a court would decide to consider customer assets as part of the company in bankruptcy proceedings. Well, would you like to find that out at court? I don't think so, because we are in a situation where there is very little legal precedence, especially in a crypto sphere, which is highly unregulated at the moment. And so in this video, I'm going to be doing an analysis of Coinbase's terms of all the user agreements, and I'm also going to be analyzing their financials as well as the disclosure that they made. I'm going to be taking a look at how they hold crypto and the legal implications in terms of mixing crypto and the fact that they're disclosing your assets as their assets on their financial statements, and how this could be a little bit misleading. Ultimately, I'm doing this video at the end of the day so that you can make your own decision and not have to wait for a situation of possible bankruptcy. So please like and subscribe to my channel, and I hope you enjoy the video and find this content useful. And if you do, please leave a comment with any of your suggestions. Cool, so let's get started. So it all starts, there was a bit of hype here in May, okay, where Coinbase includes a new risk factor in latest SEC filing as investors fear bankruptcy. So I think this article is a little bit hyped up. Coinbase is not actually filing for bankruptcy. In fact, they've indicated that they are not bankrupt. What happened was they had to include this new provision because of the latest guidance from the SEC, okay, where the SEC has acknowledged that, let me just find it here, that there are custodial risks related to crypto assets, which are different than those of other custodial relationships. This is due to increased regulatory risk as a result of a limited regulatory environment over holding these assets, technological risks, and the lack of legal precedent due to the unique characteristics of these assets. And if we take an actual look at the actual bulletin, it actually tells you here about the legal risks. So due to the unique characteristics of the assets and the lack of legal precedent, there are significant legal questions surrounding how such arrangements would be treated in a court proceeding arising from an adverse event, okay, such as fraud, loss, theft, or bankruptcy. So obviously, Brian's going to tell you that it's highly unlikely. However, I don't think he's entirely objective on the matter. And there are indeed significant legal questions, especially arising due to the fact that they are acting as a custodian, number one. There's a mixing of the crypto, which we're going to take a look at in a moment, that takes place. And that mixing, as well as the fact that they're disclosing your crypto as assets on their financial balance sheet, could arise in a situation where the court will favor creditors in a court situation of bankruptcy. So let's start with the actual user agreement. So I've got two here. And this tells us what happens when you deposit your crypto or you buy and you hold your crypto with Coinbase. Okay, so like I said, I've got two here. This one's actually for Kenya, and then I've got for the United States. Okay, in terms of ownership, they both essentially say the same thing. So Digital currency title. All digital currencies held in your digital currency wallet are assets held by the Coinbase Group for your benefit on a custodial basis. Among other things, this means A. Title to digital currency shall at all times remain with you and shall not transfer to any company in the Coinbase Group. As the owner of digital currency in your digital currency wallet, you shall bear all risk of loss of such digital currency. Okay, I don't think we need to go further than that at this point. Basically, they're saying that you retain ownership, okay, which is a breath of fresh air compared to what we were dealing with in my last video with Celsius, where they were literally telling you you're not the owner, but we're not a bank, and there's no contract relationship. And there's no trust relationship. Okay, so this is definitely an improvement. The United States agreement basically says the same thing. There is an added feature though, which I'm going to deal with a little bit later, so we don't confuse the issues here. But it basically says all supported digital assets held in your digital asset wallet are custodial assets held by Coinbase for your benefit, as described in further detail below. Okay, they actually call it share ownership. This is in United States. Titles to supported digital assets shall at all times remain with you and shall not transfer to Coinbase. All interests in digital assets we hold for digital asset wallets are held for customers, are not the property of Coinbase, and are not subject to claims of Coinbase's creditors. So we can say Coinbase is definitely taking steps here to try and protect you, at least in terms of this provision here. Okay, and then it's saying the same thing here as the previous agreement. Okay, so all fair and well, right? They're telling you you're the owner, but now we still have this issue where you're not actually holding your crypto. Coinbase is holding it for you. So what happens when they do go bankrupt? So for that, I wanted to actually go to their disclosure. Let me just find it here. Okay, so this is now because of that SAB 121 from the SEC, the Coinbase had to include this new risk disclosure. Okay, now they're telling you the opposite. Okay, so the one hand they're telling you you're definitely the ownership, you're definitely the owner, and if you're in America, I don't know why there's a prejudice or discrimination happening there, but your crypto is definitely protected from creditors. They've now included this new risk disclosure, so it's on page 84 of their filing. And there's two things we can get from here. The one is the risk that in the event of bankruptcy. The other is this part here. As of March 31, 2022, we held 256 billion in custodial fiat currencies and cryptocurrencies on behalf of customers. Okay, so what this immediately tells you is that there's a mixing, okay, and it's all held in one pool, one wallet. Supported crypto assets are not insured or guaranteed by any government or government agency. We have also entered into partnerships with third parties, such as with the Center Consortium as a reseller of USDC, where we or our partners receive and hold funds for the benefit of our customers. Okay, our and our partners' abilities to manage and accurately safeguard these customer assets requires a high level of internal controls. I'm just going to go down here to where it talks about bankruptcy. Moreover, because custodially held crypto assets may be considered to be the property of a bankruptcy estate, in the event of a bankruptcy, the crypto assets we hold in custody on behalf of our customers could be subject to bankruptcy proceedings, and such customers could be treated as our general unsecured creditors. This may result in customers finding our custodial services more risky and less attractive, and any failure to increase our customer base, discrimination, or reduction in use of our platform and products by existing customers as a result could adversely impact our business, operating results, and financial condition. So, like I said, obviously Brian's going to tell you, yeah, your crypto is safe, but really there is no straightforward answer to this question. Like we saw here, there's not very much precedence on this issue, if at all, and it's a highly unregulated space. So they had to include this provision, which is basically telling you that there is a risk in the event of bankruptcy. They're also telling you that we hold 256 billion in custodial fiat currencies and cryptocurrencies on behalf of customers. So we can all agree then that there is a mixing of the crypto taking place. And what is quite interesting, when you go, I think it's page 47. Nope. Okay, so here, key business metrics. Okay, this is where they've reflected the 256 billion that they hold. Okay, in addition to the measures presented in our condensed consolidated financial statements, we use the following key business metrics to evaluate our business, measure our performance, identify trends affecting our business, and make strategic decisions. Okay, and there we go. Assets on platform in billions, 256. Okay, so on the one hand, they're telling you you retain ownership. On the other hand, they're saying the assets that you hold are assets that we're going to reflect on our balance sheet, okay? And on top of it, they're using it to evaluate the business, okay? So in other words, they're saying our business, in terms of this aspect, could be worth 256 billion, when in actual fact, they owe you those assets, okay, if you've deposited your crypto with them, obviously in proportion to what you've deposited. So it's not really a fair valuation, okay, and they haven't, I've searched their financials, they haven't listed it as a liability. So for me, there's a conflict happening here where they're telling you that you own that crypto, but then on the other hand, they're declaring it as an asset, which obviously if they're looking for a loan or capital to keep growing, to keep the business going, especially in hard times where the crypto economy is down, they could be using that to secure debt or to evaluate their business as being worth that. So they did actually cover themselves in the United States agreement. They say over here, all supported digital assets credited to the digital asset wallet will be treated as financial assets under Division 8 of the California Uniform Commercial Code. So under this division, they're apparently now entitled to put it as an asset, okay, on the balance sheet. Now, if we go to that actual provision over here, let me just find it. Okay, it's this one here. Any property, okay, first of all, financial asset except as otherwise provided in Section 8103 means any property that is held by a securities intermediary for another person in a securities account if the securities intermediary has expressly agreed with the other person that the property is to be treated as a financial asset under this article. So first of all, they couldn't have done this without your consent, which if you have deposited crypto in the United States of America with Coinbase or you're storing your crypto with them, then you've agreed to their terms of use of service, which allows them to do this. So that deals with the issue of why they're disclosing it. See, even over here, this is a shareholder letter. Why they're disclosing it as assets on the platform, it's because you've given them the consent to do so. Okay. And if we go back to this agreement, and just before I do that, it makes me wonder now, how does this apply to people who are outside of the United States, because they haven't actually included that provision of Region 8. Yet, I don't see any division in their financial statements of like, where is, let me find it, 256. Yeah, assets on platform. Is this the entire of the United States? I mean, do they not have anyone depositing from other countries, and where is that showing, and why isn't it divided? Okay, so first of all, they haven't done that properly then, okay, because it's not in the user agreement for countries outside of the United States, okay. But let's just go on here. Coinbase is a securities intermediary. Okay, so securities intermediary means a clearing corporation or a person, including a bank or broker, that in the ordinary course of its business maintains securities accounts for others and is acting in that capacity. All right. Your digital asset is a securities account. Okay. So I'm going to get now into what your possible defense could be if you find yourself in a situation where Coinbase is goes bankrupt and your assets then become at risk. First, we need to consider the fact that there's a mixing that takes place. So anyone in the crypto space knows that if it's not your keys, it's not your crypto, it's not your own private wallet. The keys are being held by Coinbase. Okay, so what happens then, and as you can see, they're reflecting it all in one lump sum of 256 billion. There's a mixing of all the crypto that's taken place. So that has certain legal implications. Remember over here that, let me just see, the SEC actually says, where is it now, that there are certain legal questions, there's legal implications that can arise from a situation where you have a custodial like Coinbase holding crypto for a huge number of people, going into the billions of dollars of value. Okay, so first of all, we need to classify. I've done a diagram here. We're going to do a classification of crypto. Okay, now normally now we're talking about property ownership. Okay, when you classify things, there's two criteria that you follow. So the first is its relation to humans. Okay, so in this respect, we talk about negotiability. So we have things in the legal sphere or in commerce or in trade that are negotiable. Okay, so obviously crypto would fall into that category. And then you have things that are not negotiable, things that you can't own, like air, for example, or the ocean or national parks. They are not subject to ownership, meaning they are not in the sphere of legal commerce. They can't be traded, therefore they are not subject to ownership. Okay, so as far as relation to human goes, they fall within the category of items, that is crypto, that can be subject to ownership. The second criteria is the inherent nature of the thing. Now, for purposes of this video, I'm looking at fungible and non-fungible things. Okay, now there's a certain reason for this, and that is because a fungible affects transfer of ownership. Okay, when, what I've been saying since the beginning of this video, when there's a mixing that happens, it's called commixture or confusio. There's an actual change of ownership, and this is where creditors come in and they have a claim to the assets because there's been a mixing, okay? And as you can see, as I've just shown you, Coinbase is telling you in your face that there's a mixing because they're even recording it as assets on their balance sheet. So how is the creditor supposed to tell otherwise, by reading some other term hidden or some other disclosure later on? No, they rely on the financials. And they even openly telling you in their financials, okay, that it's used, this assets on platform is used to evaluate the business, okay? So there's a mix that's happened, okay? Before I go into that, though, I just want to tell you the difference. We have a fungible and then a non-fungible, okay? Fungible is something that's replaceable. So it belongs to a certain kind or genus like water, sugar, and then you have a non-fungible thing, an NFT. Okay, so that's something that based on the individual characteristics, it cannot be replaced. So for example, Picasso painting, or I don't know, your favorite NFT artwork. Okay, so that's why they're actually called NFTs. Okay, so a Bitcoin, for example, would be a fungible. That's why it can be mixed, because you can have a whole pool of Bitcoins. Not one Bitcoin is separate or distinguishable from another, in the sense that I can put one Bitcoin into a pool and 5 days later I can take out a Bitcoin. Whether it was that exact Bitcoin that I put in the 7 days before is not really relevant. Okay, so going back to mixing, the mixture, what actually happens when you have commixture or confusio? So commixture is the mixing of solids and confusio is the mixing of liquids. What happens is the mixture becomes a joint property of the owners in proportion to the value of the things included in the mix. This is why creditors have that claim, okay, over the crypto assets. So there's 3 elements. And this is where I'm going to get to what your defense could be if you find yourself in this situation. The one obvious element is that the things mixed belong to different owners. Okay, so I actually need to check. I'm not sure how many users Coinbase has, but let's just say there's a couple 100,000 or million users. There's a mixing of the crypto assets. Okay, like let's say each user is bringing in, I don't know, a tenth of a Bitcoin, then that's all getting mixed up, because it's not a situation where you're each having, and it's all different owners, and it's not a situation where you're each having your own private wallet with your own keys, okay? Because Coinbase is acting as the custodian. The second element is that there's that separation of the mixture is impossible or can only be separated with great difficulty. And then thirdly, it's done without the consent of the owners. Okay. So where consent is given, because arguably you have given your consent, where you're giving Coinbase custody of your crypto, then there's no mixing. But what happens is that the parties become joint owners of the mixture in proportion to their contributions. Okay, so obviously you don't have a claim to the whole 256 billion just because there was a mixing or an agreement to mix. Okay, so it's obviously in proportion as the agreement otherwise states. Okay. So I would say you could possibly have a defense and say that there was no mixing is because separation is possible. Then it's really just a question of getting that value back, right? So separation is possible. Okay. The only problem is that you've given your consent to Coinbase to hold your crypto as a custodian. And because of that, there could be an indication of ownership or of joint ownership happening. Now, where Coinbase has acted in your interest is they have openly declared that you retain ownership. Okay, it's not a situation of joint ownership. So yay to Coinbase. Okay, they have done that. So you are the owner. However, the issue is that they are declaring it as an asset on their financial statements. Okay, and they're doing so in terms of this over here. Okay, this region 8 in terms of the agreement. Division 8 of the California Uniform Commercial Code. So there's still that risk. The only thing I would say now in conclusion to this video is that if you read these definitions, like for example, security. So what you have now is the security account. If you're in the United States of America, it says here that security, except as otherwise provided in Section 8103, means an obligation of an issuer or a share, participation, or other interest in an issuer or in the property or enterprise of an issuer. So where the problem could come in for you in the United States, and especially even outside, is because you have consented. Actually, no, this is for the United States. Because you have consented that Coinbase can list it on their financial assets, okay, for part of their business evaluation, which obviously they need for the day-to-day running of the business and functioning and reporting, you would fall then under a creditor. And you run the risk then that because of that consent, the court will favor a creditor in the case of bankruptcy. You could perhaps argue that because of the nature of these definitions, you have a shareholding in Coinbase. So there is that angle. If you're outside of the United States, I still think it's risky in the event of bankruptcy, because even though you're saying that, and they in the agreement that you're retaining your ownership, there is always that risk, like they have declared in their document over here. They are telling you that in the event of bankruptcy, it's really, there is no precedent. And I don't know about you, but I wouldn't want to wait and see. So to conclude then, in my opinion, the odds are in the creditor's favor. So whether you're in America, it's because you agreed that Coinbase could list it on their financial statement, which is obviously what creditors will rely on when lending. And even if you're outside of the United States, the fact that they're disclosing it as assets on their balance sheets also, in my opinion, unfortunately does not work in your favor. So while you would have a leg to stand on and you could put up a good fight in terms of there being an agreement that you retained sole ownership, even though there's a mixing taking place, you would really have to put up a good fight in that case, and you would have to really argue the merits in your favor for court to consider you over the creditors. As I always say, keep as much as you can in your own wallet under your own keys. I hope you enjoyed this video, guys, and yeah, I'll see you in the next one.